Hello, my name is Vibhavsar,
And I'm Neha Venapusa.
and we are presenting Hustler Magazine versus Falwell.
In November of 1983, Larry Flynt, a publisher for Hustler magazine, came up with an idea for an ad. Hustler magazine is a monthly publication with a raunchy reputation that rivals even Playboy. So keeping true to form, Flynt wanted to parody a Campari liquor ad, where the celebrity endorsement talks about their first time with the drink, which is intentionally worded with the double entendre in mind. Flynt decides to write his parody as a fake interview in which Jerry Falwell, a prominent television preacher and political commentator, details his first time with his mother in an outhouse while drunk on Campari. He did make sure to include a disclaimer statement at the bottom, letting readers know the ad was not meant to be taken seriously.
Jerry Falwell was a nationally known minister and active commentator on both political and public issues. He decided to sue magazine for libel, invasion of privacy, and emotional distress in federal district court in the Virginia area. Flynt is granted motion of summary judgment on the invasion privacy claim. The other two claims go to the jury.
The jury decides to dismiss the libel claim due to the defendant's argument that no one could reasonably believe what was said in the false interview as true. However, the jury does grant Falwell the ability to collect damages of $150,000 from his claim that Flynt intentionally inflicted emotional distress.
Flynt appealed, but the Fourth Circuit affirmed the lower court decision despite Flynt's argument that prior case, New York versus Sullivan in 1964, set standards for actual malice, which we will get into later.
Writ of certiorari is granted to the case, as the case deals with federal questions that pertain to the First Amendment. The Supreme Court now has to deal with two issues. The first is whether Hustler magazine's publication of the offending ad is sufficiently outrageous to constitute intentional infliction of emotional distress, and two, whether the court's interest in protecting public figures from defamation is more substantial than their interest to protect the First Amendment right of free speech.
The first preceding case they looked at is the defendant's argument, the New York versus Sullivan case. Here, the court ruled that the First Amendment protection restrict ability of American public official to sue for defamation.
The New York Times published an ad put out by Martin Luther King supporters that criticized the way police treated civil rights protesters. The police sued the newspaper for defamation. The court ruled in favor of the police, and the Times appealed to the state Supreme Court, and then the U.S. Supreme Court, who then decided that suing the Times was a violation of the First Amendment.
Plaintiffs have to prove defamation as well as actual malice, meaning defendant either knew the statement was false or recklessly discarded whether or not it was true. The court also decided the fact that the ad could not reasonably believed was irrelevant because the issue was whether the ad was sufficient outrageous.
The Supreme Court decided that Falwell would not be entitled to compensation for emotional distress because he could not prove actual malice based on the standards set by the New York v. Sullivan case in 1964. Also, the state's interest to protect free speech was more substantial than its interest to protect the plaintiff from emotional distress.
If Jerry Falwell had not been a public figure, the Supreme Court may have ruled in favor of Falwell as the ad was fairly outrageous and there are different standards for private citizens.
Interestingly, in the aftermath of the case, Falwell and Flynt started to meet up at universities to talk philosophy, and eventually became friends and even sending each other Christmas cards.